Hey everybody, welcome back to the channel. Today we're going to be talking about the DIC 24, which is a legal document that you are given by a police officer if you've been arrested for DWI. My name is Brian Foley. I am your friendly Conroe DWI lawyer, and this is a really long form, so we're going to kind of read some parts of it and get a little legally taxing, but I'm going to explain it in plain English for everybody. This form is something that gets read to you by the police if you've been arrested for DWI. You have to already be under arrest for DWI for them to ask you the questions in this form or for them to read it to you. This is called the statutory warning, and that's the label it has at the top of the page on the DIC 24. At the top right-hand corner, it'll say DIC 24. And you could look this up on the web, on the DPS website, and we'll put a link to it in the article that we have on this. So the first part is the subject's name, their driver's license number, their date of birth, their race, sex, height, weight, eye color, really that means hair color, the date of arrest, the time of arrest, and the county of arrest. And the first line of the DIC 24 is this: you are under arrest for an offense arising out of acts alleged to have been committed while you are operating a motor vehicle in a public place or a watercraft while intoxicated, or an offense under section 106.041 of the Alcoholic Beverage Code. And you'll be asked to give a specimen of your breath or blood, which will be analyzed to determine the alcohol concentration of the presence of a controlled substance, drug, dangerous drug, or other substance in your body. And here's the key part. The DIC 24 is a document used to basically try to suspend your driver's license when you get arrested for DWI. If you refuse to give a specimen, and this is the next paragraph, if you refuse to give the specimen of your breath or blood, or urine technically, but normally they're asking for breath or blood, that refusal may be admissible in a subsequent prosecution. So it's like you have the right to remain silent except for your refusal for DWI. Your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 180 days, whether or not you are subsequently prosecuted for this offense. If you refuse to submit to the taking of a specimen, the officer may apply for a warrant authorizing a specimen to be taken from you anyway. So they say right off the bat, if you consent to this and let us draw your blood or do a breath test, then, it's going to be better for you than a refusal. A refusal is automatically going to be a 180-day suspension unless you request an ALR hearing, which is something we do for a lot of clients. So let's keep going. This is the part that talks about if you're under 21. So both, whether you're over or under. So if you are 21 years of age or older and submit to the taking of a specimen, and an analysis of that specimen shows you have an alcohol concentration of 0.08 or more, you'll have a suspension for not less than 90 days, whether or not you're subsequently prosecuted for the offense. Could be higher if you have a DWI second or something like that. If you are younger than 21 years of age and have any detectable amount of alcohol in your system, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 60 days. Okay. However, if you submit and it shows you're above 0.08, you may be subject to criminal penalties less severe than those provided by Chapter 49 Penal Code. If you submit to the taking of a blood specimen, the specimen will be retained and preserved in accordance with Article 3850 of the Code of Criminal Procedure. So that basically gives us a chance as the defense to try to test the blood ourselves if we think the lab is no good at DPS. And then it says if you are operating a motor vehicle and you refuse to give a specimen or provide a specimen that shows you have an alcohol concentration of 0.08 or more, you may be disqualified from driving a commercial motor vehicle for a period of not less than 1 year. And here's the key part about the ALR hearings. You may request a hearing on the suspension or denial, and this request must be received no later than 15 days after you receive or are presumed to have received notice of the suspension or denial. The request can be made by written demand, fax, or other form prescribed by the department. The officer then certifies he's informed the person both orally and in writing of the consequences of refusing to submit to the taking of a specimen. And then they ask for your signature, basically. The officer will then check a box. It'll be either breath or blood. I am now requesting a specimen of your, normally they check blood, and then consent. First checkbox here is the subject consented to allow the taking of a specimen, but refused to sign below. And then the next one is I'm voluntarily consenting to the taking of a specimen. I've been asked to submit to a specimen and have been informed of the consequences of not submitting as evidenced by my signature. And then you can sign right there. They've changed this. It used to be the only time you would sign is you're signing that you're refusing. Now they have where you can sign for consent or refusal. And there's different boxes. If you consented but you refused to sign, they'll check a box for that. If you refused and you refused to sign, they'll check a box for that. That means you're probably getting a warrant. And then if you are a child, as defined by 5102, they have to videotape this. And then they'll put the officer's signature, their printed name, and the agency that they work for. And that agency is important because when we're requesting an ALR hearing for our clients, we need the agency so we know where to send a subpoena. What we'll do is subpoena that police officer to an ALR hearing or an administrative license revocation hearing. And then if the officer doesn't show up, we're going to win that hearing. If he does show up and they can't prove that they had reasonable suspicion to initiate a traffic stop or probable cause for the arrest, or they can't prove that you refused. And we've had this where people have consented to taking a specimen and they just checked the wrong box. And DPS and the license folks thought that it was going to be a refusal, but it really wasn't. So we've won cases like that as well. So that, folks, is the DIC 24. That's just about every word of it. And I got to be the only person on YouTube trying to discuss that. So if you want a very nerdy lawyer who knows about every word on that form and can explain it like that, you might look at our law firm. If you needed just that information, if you're a police officer looking at these cases, one thing you want to do is make sure you read that correctly and clearly. And if you do so, then people can make an informed decision and you're going to be less likely to get in trouble with your superiors for not following the right procedures, or less likely to get in trouble with a lawyer like me on cross-examination, as long as you're taking your time and giving everybody a fair opportunity to understand they do have the right not to consent to a blood test, or if they do want to consent to it, to understand the consequences of refusal for their license. Thanks, everybody. As always, these are for educational purposes. If you like what you saw, don't forget to like and subscribe, and we'll see you next time.